ask us to proceed on 124378. Ms. Frost, you may proceed.
Morning, Madam Chief Justice, and may it please the court. The Court of Appeals found the appellants had no standing to challenge subsections A2 and A3 of 25-2438 based on the majority's finding that these subsections require a deceitful state of mind. This was contrary both to the law's plain text and this court's standing precedent. As this court most recently explained in City of Wichita v. Trotter, a plaintiff challenging a law as overbroad need not establish a personal injury from that law. So, for example, in Trotter, the court admitted it knew nearly nothing about Trotter's circumstances, but it did not matter because a law is unconstitutionally overbroad if its plain language can make constitutionally protected conduct criminal. In Trotter, this court applied that test asking, does the plain text limit the application of that statute to commercial speech, which is not protected by the overbreadth doctrine? Here, appellants are asking the same question. It is simply, can the plain text of A2 and 3 be read to reach appellant's activity? The only way to find that it cannot is to rewrite the statute. This case is a lot like Bodiger. In that case, this court considered Kansas's criminal threat statute, where the mens rea in that statute required only an awareness that words may be seen as a threat, not the intent to threaten. This court found the law was unconstitutionally overbroad because, as written, it could reach, for example, lyrics said near the police in protest with no intent to intimidate or to threaten. As written, A2 and 3 can reach protected conduct. In fact, several people have come to that conclusion. Fear that it will reach protected conduct is severely impeding the Douglas County Clerk's Office's operations. For years, they have relied on organizations like the appellants to do this kind of election official related work. The Douglas County Clerk's—
Can I interrupt you there, Counselor, and ask? So I was tracking your argument, which is very clear on the face of the statute that if there's no essentially reasonable person standard here, the claim is, look, we can't be responsible for the subjective interpretations that any person out there might give to our activity. But then you move into, but we're working with the Douglas County Elections Office. And those two things seem different to me. So that's why I interrupted you and I wanted to ask about that. So specifically, as I understand your client's claims, they, at least in part, are we in the past have not been official agents of the office, but we've carried the office's signs. We've used materials that have the seal or the markers of the Douglas County Election Office on it. And so my question is, why is that protected activity?
Well, it's absolutely protected activity because they are engaged in these voter registration and education efforts.
I'm asking specifically about carrying materials that mark them out as agents of a government agency when they're not.
So I don't think they are carrying materials that mark them as agents of a government agency. What they're doing is carrying the official registration forms so that they can help people register to vote. Right.
I understood, and I may correct me if I'm wrong, but I understood Mr. Shu, I think I'm saying that correctly. There was an affidavit filed or something in the record about that his office providing your clients, or at least the organizations, materials, signs that basically said Douglas County Elections Office.
So the materials, I believe, and I'll be completely candid, I'm not sure exactly what they say, but what I understand that affidavit is that they're, for example, documents that are official voter registration forms that come from the county. They're materials that maybe say voter registration here that also have a county insignia. I think part of the thrust of that affidavit is that you actually, in order to be effective, in order to be able to register voters, you are going to be more effective if the voter knows that you are working with the election officials, and they are. It's not
So
false.
that's my question, is
Right.
that why is that protected activity? In other words, why can't the legislature say you're not allowed to hold yourself out as an agent of the state when you're not?
But they're not holding themselves out as an agent of the state. They're working with the state, and people are misunderstanding what they are doing. And I think in A1, we don't challenge A1, and we absolutely agree that if they are falsely intending to create a false impression, that's one thing, but that's not what A2 and A3 do.
But what if, so that, this is why I started out by saying it matters. This distinction seems to matter a lot with respect to whether or not we're dealing with a reasonable listener. A reasonable person might conclude that a person who is carrying documents that have official county insignias and so on, they might reasonably conclude that person's an agent of the county.
But that's not what the statute says.
Well, okay, fair enough. But that's why I'm asking this question about couldn't that be a lawful ends of a law if it was a reasonable person?
So I think, Your Honor, if you look to Meyer, for example, you'll find that actually the answer is no. Absent some indication that the activity is actually fraudulent, is actually trying to hurt voters. I mean, the irony here is the conduct that my clients are engaged in is to help voters. They are not attempting to mislead anyone, and in fact, they're facilitating their rights. And so, for example, if you look at the United States Supreme Court's decision in Meyer, right? One of the things that the state did there is they said, you can't have petition circulators who are, from out of state. If you're circulating a petition, this is a good example, you have to wear a name tag so that people know who you are and where you're coming from. The court said, no, absent some evidence that these folks are engaged in some kind of fraudulent behavior, no, it impedes too much on core protected activity. Here, we're going much further than saying, hey, you just can't hire a circulator if they won't wear a name tag. We're actually saying, hey, you can't, you are in the line of potential criminal prosecution if someone misunderstands that when you're working with the state, they think you're an elections official. There has to be something more there. But I would say, honestly, you don't even need to get that far because there's so many problems on the face of the statute that, you don't have to dig that deep. I mean, honestly, if one switches.
And sorry, again, just that's why I sort of jumped in, because I was a little surprised that you went right to this, because it seems like if there's no reasonable person standard here, you have an easier claim. Well, that doesn't require Amy Shu's affidavit, frankly. Am I wrong about that?
No, I think that's right. I actually think this is very, very much could be decided completely on the law, frankly, without any affidavits. We pled 3 different speech related claims, right? Overbreadth and vagueness, which frankly don't require any evidence at all. The third claim, which is why the affidavits are in the record from the Douglas County Court from my clients, is your sort of more generic impediment on speech rights. And there you get more into the reasonable fear of prosecution.
What's your position on the reasonable person standard, and does it come into play under the statute? There's no mention of it anywhere.
Yeah, it's just not in the statute. It's just not there. And I think this is, the legislature obviously knows how to write a reasonable person standard. They do it all the time. They just didn't put it here. So this court can't read into the statute a reasonable person standard that isn't
Let me
there.
ask you a question on that statutory construction. The legislature has provided a definition of knowingly, and there are 2 different definitions. One, when knowingly modifies the conduct, and a second definition when knowingly modifies the consequences of the conduct. That latter definition incorporates a reasonableness standard, right? So when we're looking at the definition of the crime under 252438, subsection 3 in particular, it looks like knowingly, or that entire subsection, the conduct is really completely intertwined with the consequences of the conduct. I'm wondering why knowingly in subsection A, why we wouldn't impose the second definition of knowingly. In other words, applying to the consequences. You have to know that a reasonable person would have understood that conduct.
Yes, Your Honor, and I don't think we disagree with that. I think our argument is actually part of the problem here is we know, first of all, there's no reasonable person standard, so if we take that out, but that we know that our activity can cause some people to mistake us for election officials. So I think our argument is that the knowing applies to both, but that it doesn't matter, both because it's overbroad, it reaches, too much constitutionally protected material. And honestly, it's still not clear what A2 and A3 are really supposed to reach that isn't covered by A1 or the previously existing false misrepresentation of oneself as an election official or employee, which by itself has language the legislature put in there that says with knowledge that it will cause that result. So I think this statute is just kind of woefully missing all of the signposts that you would expect.
I guess I'm focusing on the overbreadth challenge to subsection 3 specifically. And if knowingly is, if we use the second definition under 215202 subsection I, that knowingly with respect to the result of a person's conduct is knowing when such person is aware that it's reasonably certain to cause the result.
Right, and under the plain language of the statute, I think what we are saying is we know that when we engage in these voter education registration efforts, the public doesn't necessarily always understand what's going on. So that's why we say we fall, at least under the plain text of the statute, it could reach our activity. And I think a second problem that you have.
Reasonableness doesn't, objectively reasonable standard under subsection 3 doesn't save it from your overbreadth challenge. Is that?
Well, I think that's true. I also think it definitely doesn't save it from the vagueness challenge. And I recognize I'm over time, but if I may briefly, if you look at this court's decision in Harris, I think like the statute in Harris, A2 and 3 are unconstitutionally vague, first and foremost, because they invite arbitrary enforcement. So as a sure sign of subjectivity in action, county DA reads the statute one way, the attorney general or the former attorney general, we don't really know how the current attorney general reads it another way. Court of appeals judges disagree on how to read it. County clerks read it differently. And it raises enormous difficulties for those who must enforce it. It raises questions like for A3, the one Your Honor was just talking about, it prohibits conduct that would cause another to believe they are an elections official. So whose belief is that? How reasonable does that belief have to be? There's just no objective standard for enforcement. And if you read a safe harbor in, if you read some sort of reasonable standard in, what is enough to trigger that safe harbor? No one knows.
Can I pursue, I used the phrase earlier, reasonable listener. This is a somewhat theoretical question, I guess, but this is all about speech, right? You would agree with that.
Correct.
I think everyone agrees.
Expressive conduct, yes.
Expressive conduct, we'll call it speech. Isn't speech or expressive conduct, doesn't it necessarily imply or require a reasonable listener? In other words, there's two parties, it's communicative behavior, and there can be no speech without that reasonable listener. I mean,
No, Your Honor, I disagree with that. I think what the case law talks about expressive conduct, I think the first half of that is correct, which is that expressive conduct is defined by conduct that is meant to convey a message and that the listener is likely to understand that message. But that's a very different thing, which is what kind of conduct is protected by constitutional provisions that protect speech. From what kind of conduct can you criminalize?
No, I agree. I mean, certainly that's the case. I'm asking a statutory interpretation question, really, which is when the legislature is on the subject of speech, why doesn't that include a reasonable listener?
Because I
It's-
think, Your Honor, in fact, that undermines the whole sort of basis of why we are so careful and demand such specificity in this space
Well,
specifically.
So if this statute said, if this statute explicitly said that would give the appearance to a reasonable observer in 2, or that would cause a reasonable person to believe in 3, you wouldn't have a problem with the statute. would you?
No, I don't think that's correct. I think, for example, if you look at the State v. Bryan decision, there we had, of course, the old stalking statute before the court found it unconstitutionally vague, and there was a new one. But in that situation, not only was it vague because the following prong was vague because of a subjective person reaction, but it was also vague because that prong, unlike the course of conduct prong, did not explicitly carve out constitutionally protected conduct. And I would say that in that situation, the state similarly argued that the court should read in, sort of implicitly read in a
Yeah,
different.
I understand
mens
you
rea
don't want us to do that, but I'm asking a hypothetical question, which is, let's just say we strike this down, legislature passes a new statute exactly the same as this, except it says, gives the appearance to a reasonable observer in 2, or would cause a reasonable person to believe in 3.
Yeah,
That-
I think.
How does that,
I think they would do much better to add the language which appears in the stalking statute about carves out constitutionally
why do you need
protected
a carve out?
activity. Because I think the problem is that it still begs the question of what do A2 and A3 cover that A1 doesn't, or that the false,
So do you think there could ever be constitutionally protected speech which gives the appearance to a reasonable observer that someone is an election official when they're not?
absent some actual fraud or intent to commit fraud? No.
The problem's the mens rea then is not at a high enough scrutiny to protect speech? Is that what you're suggesting, that it has to only prescribe intentional?
Yeah, Your Honor, and I think that's what A1 does and why we don't challenge it, is because it is a very different situation when someone is intentionally trying to mislead someone by either explicitly or implicitly, and A1 does not limit it to only explicit statements. I am the Secretary of State, right? By the language of the provision, it could also be implicitly, but the intent to cause that, because otherwise it's sort of, this, I mean, maybe goes to where I said you don't have to go, because I think it digs much deeper than one has to go, but is like the United States Supreme Court said in Meyer, you can't just, when you are legislating in a space where you are impeding on core constitutional conduct, you have to have some sort of reason to believe that the people engaged in this behavior are committing fraud. And there's just nothing like that here.
Is this a state constitutional claim exclusively?
It is exclusively a state constitutional claim, although of course, this court has said that.
An overlay, sure, but
Yes, but it is exclusively.
Chief Justice Luker, and may it please the court. This case presents a completely manufactured controversy in which, for inexplicable reasons, plaintiffs are asking the court to interpret the statute in the most unreasonable manner possible in order to expose themselves to criminal liability. The statute does not support the interpretation that they have advanced here, and there is no basis for invalidating this duly enacted legislation.
why doesn't it support? I mean, at least just on the face of it.
So the statute is focused on the speaker or the writer. They are trying to construe this as focused on the viewer, the views of the listener or the reader. And that's not the most logical reading of the statute. What they've done, and the district court talked about this, I believe the Court of Appeals talked about that, is they've largely ignored the word knowingly and the definition of knowingly in 215202I. 215202I talks about something being reasonably certain. So if you look at the definition and in the words, it says that in the statute that the person is aware that such person's conduct is reasonably certain to cause the result. What they have argued in their briefing and in their petition is that we acknowledge at no time do we ever mislead people
Let me give
intentionally.
you a hypothetical.
sure.
Because I'm trying to, again, understand both sides' arguments and give the best version of both sides' arguments. And I understand opposing counsel to be saying, look, we actually are reasonably certain that this will happen. And here's my hypothetical. Let's say there's polling done in a county, let's say Douglas County or Shawnee, whatever, wherever. And the polling shows that 90% of the people believe that individuals who conduct voter registration drives work for the state of Kansas. So now you've got reasonable certainty all over the place. That maybe is an unreasonable view, but it's polling data, which nobody questions.
Well, I guess I'd come back with a couple of points here. The first is, and I understand that that's the factual, but just to point out that there is, in this case, literally in their petition, they say that we never do this, and they just base their petition on total conjecture, literally on the tens of thousands of people, I think is the exact language that they use in their petition. It's inevitable that there will be someone who confuses people. So they're
That's
sort
my
of
hypothetical ratchets that way.
right. Okay,
obviously.
fair enough. And I guess what I would say then in response to the hypothetical is that when you're looking at a reasonable interpretation, we then also have to bring in the concept of Alanis, which we talked about in our brief, that the criminal law requires some sort of consciousness of wrongdoing. If the plaintiffs are able to say, look, we under no circumstances are we misleading people. When this happens, when we do have someone who's confused, we're going to disabuse them of that notion, which is what they have done in this case, then it's inconceivable, but there would be criminal exposure in that case. And I think
I'm
Go ahead.
going to press back on my
Sure.
hypothetical a little bit. Again, just under those facts as given, why couldn't an individual who was engaged in a voter registration drive be prosecuted under this statute, or at least under the plain reading of the statute?
well, I think that if that individual didn't take any acts there where there was any kind where he was engaging in the kind of conduct where there was some sort of reasonable certainty that was going to happen. I mean, the fact that we have lots of in any society, there will be people who are overly naive, who, are willfully blind. I mean, we see that in the election deniers. I mean, there's some people you're just never going to convince. But the fact of the matter is if there is no action, no culpable type of action on the part of those individuals, and I would
Isn't
simply
that
point-
why a reasonable person standard is what sort of protects the constitutional behavior?
I think that's right. And
But
can I
that's
just go
different
ahead?
from the knowing mens rea. In other words,
Your Honor, can I compare it even to what's in 5202J, which is the recklessness standard? So under our standard here for recklessness, which is obviously a step below knowing, the definition is an individual who consciously disregards a substantial and unjustifiable risk. I mean, it seems to me that if that's the standard that we were dealing with here, where you would say, well, how can we expose someone to criminal liability when they have taken whatever actions that are possible, everything that's reasonable to disabuse individuals that they are acting as an election official?
why do they have to do that? All right, why do they have to affirmatively sort of disabuse?
Well, I don't think that is a requirement that they have to. They said that in their petition that they do that. But in terms of if they hadn't included that in their petition, where they make clear that they do that, then I still don't think that there would be a violation of the statute, because if they are engaging in the kind of conduct that they are, where they're just interfacing with the public, then I don't think that would be
I'll try to just make it a little bit even more extreme.
okay.
Let's just say you have a jurisdiction and it's undisputed fact that when you wear a bowler hat in that jurisdiction, everyone there thinks you're an election worker.
Yeah.
If I put a bowler hat on and walk outside, have I broken the law? this law.
I guess when we go down that far, where your conduct now is indistinguishable from an election official, and we have, and it's, it's kind of a strained hypothetical, but I'm going to go with it. That in that circumstance, that everyone knows that you are an election official, and I think that at that point, if you didn't undertake some sort of action to disabuse them, then we were potentially looking at a violation of the statute.
Even if it's completely unreasonable to think that just because you.
Well, I mean, I think and that's part of the reason why I think, and under the case law, that you can and need to impose a reasonable
Okay,
standard. I
well,
mean,
that's what I'm driving.
and I
at, is
guess
don't
what-
you need a reasonable person standard to save the statute? That's really what all this whole line of questioning is driving.
well, I think that that can be found in the definition of knowingly, and I think that there needs to be that gloss on it. I mean, no speech is absolute, and the state obviously has a very substantial interest in protecting the public against confusion and people who are misrepresenting themselves.
you-
Go ahead.
I'll gas one more and then I'll be quiet. Let others.
You promise.
Yeah, I promise. Would it be an absurd result? Would my bowler hat example produce an absurd result if there was no reasonable person standard in it?
Yeah, I think that's correct. And I think that under your the statutory canon of construction, that's not how you're to interpret a statute.
Could you? Seems to me you're making an argument that the section 1, representing oneself as an elected official, pretty much covers it. What is the purpose of sections 2 and 3?
So
If it's covered by section 1, that to me, it seems to be require section 2 and section 3 different types of protected conduct.
Thank you, Your Honor.
Explain that to me.
Sure. I think that what the legislature was doing was trying to address more subtle conduct, that they were dealing in A1 with individuals who explicitly represent themselves as an election official.
And
And
why isn't that conduct that they're trying to get to in 2 and 3 just covered by section?
well, I think, first of all, I think that there's an argument that it could be, and I think that the fact that the legislature engages in additional, what they call redundancy, some people are calling surpluses, that's not a problem under the case law. But I think that the reality is that the legislature felt like, I want to address situations where, for example, to give a common problem that we've encountered here in the state, where individuals who are sending out, say, mailings, that have all of the hallmarks of coming from an election office, and then there would be, the legislature didn't want the state to have to get bogged down in the distinction. It's like, well, are they representing themselves as an election official, or are they simply trying to suggest that it was coming from the election office, and sort of dealing with subtleties there that the election office, that the legislature wanted to tie up. I mean, I think in many of these cases, if there would be a prosecution, and as I said in my brief, I think we're dealing with a rare scenario, but I think that there probably would be prosecutions under multiple provisions just to sort of try to tie everything together and cover your bets.
If you can't prove that I'm intending to represent an election official, why should I have to care what other people think?
I think that if you are engaging in conduct that is likely going to lead to that result, and
Don't I have a right to wear a bowler cap?
sure,
Not
absolutely.
my problem if you think I'm an election official. I have
Well,
the right to
that-
wear a cap, don't I?
There are situations, though, Your Honor, where I believe that the state does have an interest, though, in avoiding the confusion and on behalf of voters. And so, I mean, I think that for someone to say, hey, do I have a right to come in and wear a name tag that says I'm election official, I'm from the Johnson County election office, or I'm from the Douglas County election office. I mean, I think that
You're
there-
stating that as if it exists as a prerequisite. But tell me why it exists. If I send a flyer that is from the Secretary of State, why do I have to tell somebody I'm not the Secretary of State? Don't I have the right to send a flyer?
Well, I think that there's the statutes, I mean, if under that theory, Your Honor, the statutes that are on the books that prohibit misrepresentation of individuals as public officials would have to be stricken. And I
But you
think,
have to prove the misrepresentation. That's in A1.
right, and in A2 and A3, you're simply saying that this is going to lead any reasonable person is going to create that standard. I mean, I admit that it is a lesser standard than intentionality.
So your position is that I've committed a crime because I mailed a brochure that is drafted by the Secretary of State and didn't actively tell them I'm not the Secretary of State.
Well, I think that there would, I mean, we're dealing with a lot of circumstances there. I mean, but if you want to go with a hypothetical that has all of the hallmarks of an official mailing and has no carve outs, caveats, disclaimers, anything like that, then I think that would be a violation of the statute. Yes.
So your answer is yes.
If
That
there,
is a criminal act to do that.
if
Because
you are misleading individuals that.
Because it has no disclaimer, that is a criminal act in your mind.
I think, I mean, we'd have a lot of facts and circumstances that would have to determine, the mailing and what was likely to lead individuals. I think that what's happened in this case isn't present. So I'm
You
going
think
with your
that's pretty-
hypothetical.
Don't you
But-
think that's pretty chilling?
Well, I think that if you can, I mean, so under the theory that you're taking, Justice Wilson, is that even if we have a reasonable person, I mean, if someone is intending to misrepresent them, if that they are clearly misrepresenting themselves or their communication, whatever, as an election official, and it's clearly going to have that effect on the listener and clearly going to create that confusion, I think the state does have a substantial interest in protecting the public against that kind of misrepresentation.
And I take you back to your
Okay.
your statutory construction argument. And I think it's sort of the same question I was asking your opposing counsel. You cited the general criminal definition statute for knowingly, and you're choosing one of two definitions, the one that would focus on the consequences of a person's conduct, right? Which
Correct.
then gets you
Correct.
your reasonable
That's
or
correct.
objectively reasonable person standard. So knowing that there are two different definitions and just looking at the face of 25-24-38, is it ambiguous whether knowingly modifies conduct or consequences? Do we have to get there under a plain language construction, or do you think we have to find this ambiguous? Because it doesn't clearly direct us under the definition of the crime, whether knowingly modifies conduct or consequences.
I think that's clear from your decision in State v. Hobbs. I think that State v. Hobbs makes clear that definition needs to apply to all elements of the statute. And you've made that clear in Hobbs. And so I don't think that really should be in question. And I think that it does incorporate every element of the statute, the word knowingly, and both in the 5202I and in the in the 25-24-38A. So I think it's going to reach all subprovisions. Yes.
So in light of Hobbs, we can reach it under a plain language construction that both definitions apply. The definition of knowingly that applies to conduct and the definition of knowingly that applies to the consequences of your conduct.
That's correct. Yes.
Okay.
That's our interpretation.
I was going to ask both counsel, and I think maybe this is what you were relying on generationally through Hobbs.
Sure.
Is 215202F, which provides that if the definition of the crime prescribes a culpable mental state that is sufficient for the commission of the crime without distinguishing among the material elements thereof, such provision shall apply to all material elements of the crime unless a contrary purpose plainly appears.
Right. I mean,
What you're saying
Hobbs was
is that-
using that subsection F to reach the conclusion that it needed to apply to every component of the statute, the culpability, the mens rea element. That's right.
That's
That's correct, Your Honor.
clarified that
Yes.
is what you were focused on.
Yes, Your Honor. Yes.
Okay, so What I'd like to focus, and I'm gonna do a hypothetical, I'll warn
Okay.
you in advance. You're getting a lot of hypotheticals.
Fine.
But, we're talking about standing, and there's two ways you can establish standing, the pre-enforcement challenge and then the overbreadth. So on when you're talking about what you led off with, that the knowingly statute, knowingly, a person acts knowingly with respect to a result of the conduct when such person is aware that such person's conduct is reasonably certain to cause the result. Okay, so when we look at 2, engaging in conduct, knowingly engaging in conduct that gives the appearance of being an election official. Here's my hypothetical. And it doesn't have to do with elections, but I work for Food Tasting LLC. And so every Saturday I go to Costco and I have a little smock and it says Food Tasting LLC, and I'm at an end cap and I'm handing out food. And every time I go there, and the Costco people, if you're frequently go as much as I do.
I am familiar with that hypothetical.
Yes, they wear Costco shirts that say Costco, but my shirt doesn't say Costco, right? So, and inevitably people come up and say, where are the paper towels? Okay, well, since I'm there so much, I say, I don't work here. I don't work for Costco. Okay, I'm an independent contractor, but paper towels are just right down there, 4th row over. Okay, I know. Okay, I'm engaging in conduct. I am knowingly engaging in conduct that gives the appearance of being a Costco worker, right? Because I know. And the reason I know is because, I'm reasonably certain of being mistaken as a Costco worker because I have been mistaken as a Costco worker, right? So what's wrong with that analysis? I mean, why don't you just have standing based on that?
Well, the standing here needs to mean a couple of things. First, that there needs to be a reasonableness to their concern about liability. I mean, when they have said that in all of their interactions that they have disabused people and they have engaged in total speculation when they said, look, among the literally tens of
Well,
thousands.
but they've
Okay.
done more than engage in speculation. They've attached affidavits that say people have mistaken them, right?
Yes, in which they've then disabused them of that notion. That's correct.
I don't work for Costco. I work for Tasty.
Correct.
Right.
Yes.
So
Right.
I don't understand. I mean, if the standard is knowingly, my conduct, when I am aware that my conduct is reasonably certain to cause the result.
Yeah.
When it has caused the result.
Well, I guess when we're looking at, I mean, if there was a criminal provision there, I don't think that.
Right, I'm assuming
Okay.
there's
Okay, yeah, all right,
It's a
so-
crime. It's a crime to impersonate
Yes.
a Costco worker.
Okay. So, and I guess in that scenario, we're looking at is it on the reasonable certainty component of it? I mean, there may not be a rational basis for exposing someone to criminal culpability in
Well,
that
no, now you're getting
circumstance.
to the merits.
Okay.
I'm only
Okay.
talking about standing.
Yeah.
Okay, I'm talking about standing, and to have standing, I have to show that, knowingly engaging in conduct that I know is reasonably certain to cause the result. And then when you get to subsection 3,
Yeah.
engaging in conduct that would cause another person to believe a person engaging in conduct is an election official. It's, I'm causing that. And then that, even when you get to overbreadth, where you don't even have to show that, subject to threat, arrest, or prosecution, it's enough that the mere existence of the statute would cause a person not before the court to refrain from engaging in that constitutionally protected speech or expression, which is me, being able to work for Food Tasting Inc. And isn't that the case here, that because I'm so uncertain as a Food Tasting Inc. person about whether I am gonna, whether I know I'm knowingly engaging in this conduct, that's a given. and whether, and I'm reasonably certain that someone is going to mistake me for a Costco worker. And so in order to avoid prosecution, I'm not going to work there.
Yeah. And I guess there still needs to be, and what I would then come back with, first of all, to sort of address the specific standing, I think that's in this scenario, it is ultimately integrated with the statute. I mean, what they're sort of taking the position of is ignore the statute. We have a subjective, our subjective chill based on how we construe it, even if it may be unreasonable.
Not
and therefore
subjective. They've experienced it. They have affidavits that show people have mistaken us.
They have said is in their affidavits is that it's inevitable and that we know that of the tens of thousands.
No.
So if that.
No, we know.
So if that is the case, Your Honor, then what happens? I mean, where do you draw the line? If you say, look, there are.
Exactly. Do you
Yeah,
draw the
there are-
line at one person out of 10,000?
And
Or is it 5 people out of 10,000? Is it 30 people?
that's a great point. And my response to that, Your Honor, is that there needs to be a reasonableness component. I mean, I come up with the.
Okay,
from
so
pop culture.
there has to be an evidentiary hearing
Well,
for
I mean,
every person to, as this person is charged criminally, every person has to come. Are you reasonable? What is your educational background? What is your IQ? What is your level of experience with voting? What is your level of experience of engaging in community service? So every person.
Your Honor, consider like a pop culture. I mean, if you have, the movie where I forget the name of the movie where the guy says, hey, do I have a chance? And she's the 1 in a million. So you're saying I have a chance. And I think that in that sort of scenario, I mean, sure, statistically, if under that theory that there could be, and, inevitably will be in our society, the willfully blind, the folks who are denying elections, the example I gave earlier. But if we take your hypothetical, well, sure. I mean, in 1 in 10,000, then
Why would
they have standing? I mean,
with the threat of going to jail, 1 in 10,000, when frankly, I bought a lottery ticket when it was $1 billion. Okay. Why would I at 1 out of 10,000 put my freedom at risk?
I think that is, with respect, I think that would not be the reasonableness on the statute. And I think I mean,
So you
that
get
kind-
before a
and you'd
district
have
court
rule of
judge.
lenity that would apply in that scenario that would probably invalidate any potential conviction. I mean, I think that at a certain point, lines have to be
Well,
drawn.
counsel, isn't the reasonable person test a legal test? It's not
Yes.
a fact test.
Yes, that's correct.
And isn't that, I mean, it just sounds to me like that's what you're arguing. You're saying this statute includes a reasonable person. component.
Correct, Your Honor, yes.
Well, what is a reasonable person under this test? A reasonable listener.
Well, I mean, I guess that's
What
how,
is gullible? What is, what is a reasonable listener?
yeah, I mean, and I think,
Does it
again,
have to do with, we have lots of legal tests that talk about education, whether, life experience. I mean, so it is, even though it's a legal test to determine the ultimate legal determination about whether it's reasonable, we have a reasonable standard. There shall be no unreasonable search and seizure, but it's all fact driven when we get to whether or not it's reasonable, right?
right, but that's no basis for invalidating the statute altogether as on a facial challenge.
From your
which is what we have.
perspective, but from the person that's, has the risk of jail, I mean, isn't it chilling? Isn't it under the second test, the overbreadth test, the mere existence of the statute could cause a person, this is just for standing.
Mhm.
This is not the substantive overbreadth test, which I will mention was erroneously used by the Court of Appeals. They erroneously used the merit, the overbreadth test in discussing the merits. They use that for standing, but the correct standing test is the mere existence of the statute could cause a person not before the court to refrain from engaging in constitutionally protected speech or expression.
Well, I guess I would come back, first of all, on the latter point, I would respectfully disagree. I think that that integrating the statute, there's no reason why you'd have sort of that gap. I mean, if the statute itself properly interpreted doesn't create the kind of standing, I don't think that the Court of Appeals did anything improper in sort of evaluating it like you did. But let me go to the kind of the first part of your argument, which is that I think that when they for that individual, I mean, there ultimately there has to be a reasonableness component to it. And ultimately, I mean, this is going, I mean, if you had a prosecution, which seems incredibly unlikely, but if you had one, then it would get addressed at the outset. I mean, I understand that the court feels that
And then I
that's,
have to, who's going to pay my legal fees?
well, I mean, I guess that this is, I mean, frankly, if you had an unjustifiable prosecution like that, probably the state's going to end up having to, for, you know, some sort of, I don't know what's the.
Yeah, we don't know because
Right. I
we,
mean,
you know,
the bottom line is, I think that would not
Arbitrate,
be
you know.
I think that there needs to be a greater degree of deference to the legislature on, you know, when they're adopting a statute and drafting it in a way and putting the court needs to interpret it in a way that avoids those kind of scenarios. I think if you have a reasonableness component to it, then that in this scenario renders the statute valid.
but I would just, as a final note, we don't have a reasonable standard when you're reading the plain language of this of the statute.
Well, I think in 5202, I think that 5202I, I think incorporates that. So I would respectfully disagree with that.
I'm sorry, can I ask one last
Certainly.
question? I think I heard opposing counsel argue that maybe reasonable standard wouldn't be enough to save subsection 3 in particular. I didn't hear you respond to that argument specifically, but what is?
Well, I think that it is implicit in there. And I think that, yes, I mean, I think that is going to be needing to, I think that right now it's already in there with the definition from 5202I. And I think that that when it's in there, I think that will clearly help both subsection A2 and subsection A3 pass any kind of constitutional challenge. And I don't think that we even need to get there. I think, you know, it can be resolved at just in the statutory interpretation level.
I would like to inquire about your target on your application of 5202I. When you say reasonable person, are you talking about the actor that could possibly be criminally charged? Or are you talking about reasonable person as to the person who's receiving the information or whatever?
I'm talking about the actor there. And if you are, as the actor, when you're dealing with a potentially, you know, naive, willfully blind individual, I mean, and that person perhaps gets confused, that doesn't mean that your conduct as the actor, as the drafter, has been unreasonable. So the focus is on the speaker, the defendant, if you will, not on the listener.
But the language is that the person is reasonably certain to cause the result. Not reasonable, not to believe that it would be reasonable that what I'm doing would.
Yeah.
But it would be reasonably certain to cause the result. And don't we have affidavits that establish that it is reasonably certain to cause the result?
Well,
Because it
what we have is affidavits saying that in tens of thousands of interactions that we've had, it's inevitable that there will be these kind of things happening. I mean, that there have been, according to the plaintiffs in their apparently mind reading, telepathic, whatever it is, that they claim that they have encountered some individuals who have been confused, notwithstanding their efforts to disabuse those individuals of that effort. And I would say that in that scenario, that would not support a criminal prosecution because their actions in those facts, in those circumstances have not triggered the statute.
Why
They have
not?
not
I don't
acted
understand that.
unreasonably.
I don't understand that.
What's missing?
So, well, I think that there is a reasonable certainty. And so when you're looking at the rational, you know, logical, I mean, that behavior looked at isolated would not lead a person, you know, if they are reasonable and a rational person. And I realize that we're focused on the speaker, but I think that the fact that I have engaged in reasonable conduct and someone else misconstrues that reasonable conduct does not expose me to and can't expose me to criminal liability.
You need a reasonable listener standard.
Yes.
You just do, right?
I mean, I think that is, maybe it's sort of,
Let me give you,
yeah.
and I'm breaking my promise to Justice. It's all right. Statute of limitations passed. What's your best argument that the statute has a reasonable listener component? And I don't think you can rely on 5202 for the reason Justice Luker pointed out, which is 5202, the knowingly definition, talks about a reasonable speaker, not the reasonable listener. So what's your best argument that the statute contains or ought to be construed to contain a reasonable listener standard?
Well, I think that the case law says that you need to, the court generally in interpreting a statute is going to apply it in a way that will ensure that it passes constitutional muster to the extent that's possible, particularly on a facial challenge and in the face of an overbreath challenge as well. And I would say that if that, just sort of like what you did in the State v. Huffman case back in 1980, that if you think that that is necessary because in order to avoid some unjust result, then I think that the court can say, look, we're going to apply that interpretation of the statute. You're not adding words, you're simply putting an interpretation of the statute in a way that it would then ensure that no absurd results flow therefrom.
And if you do so, incorporate that reasonable listener standard, is that still consistent with the legislature's intent in enacting the statute?
Yes, I think the legislature, what their focus is to avoid individuals from being misled and the public from being having misapprehensions that individuals who were not election officials were acting as such. And so I think that that is entirely consistent with what the legislature was intending to do. Further questions? Thank you very much.
Ross, you reserve 4 minutes.
Madam Chief Justice, just a few points. If, as the state's counsel conceded, there is an argument that A2 and A3 can be subsumed into A1, that is a reason to find 2 and 3 overbroad and sever them from the statute.
Hey, I was gonna, there's not a non-severability aspect of this, is there? Was that included in this legislation?
So yes, in this legislation, it says there is a severability clause. You can take 2 and 3 out and A1 can survive. That is how you
Get there, would that be relief you're requesting?
That is the relief we're requesting. Second, opposing counsel also mentioned election deniers in the discussion of reasonable people. I don't think this court can ignore that is the context in which this was passed, a context in which election officials are regularly being harassed across the United States and threatened, and yet still the legislature did not include a reasonable person standard. This court's decision in Richardson says that you can't replace one mens rea requirement with another. If there was no mens rea requirement, then maybe you could read something else in, but there is a mens rea requirement. It is knowing, and the state is asking you to effectively rewrite the statute.
Let me just ask you too, is if we agree with you that they're standing, what do we do?
Yes, Your Honor, we would ask that you reverse the Court of Appeals and direct the district court to enter the temporary injunction. Find that we are likely to succeed on our challenge to A2 and 3.
So we'd go back down to district court.
Correct, Your Honor. The League of Women Voters has done voter registration in Kansas for over 100 years. The other organizations who brought this lawsuit are deeply committed to this work and have done it for years. They have severely curtailed their efforts. It is frankly absurd to suggest that they have brought this lawsuit and curtailed their activity for just the fun of it. They are afraid because the plain language makes them afraid. And that
We wrote a decision that said this statute's construed to include a reasonable listener standard. Would they no longer be afraid?
I think, Your Honor, as we discussed when I was first up here, there are so many other issues with the statute. I think this is one that just needs to be stricken. And if the legislature wants to try again, it can try again. But I don't think a reasonable person standard alone, it's certainly a very obvious problem with the statute, but alone, I don't think it gets you past all the constitutional hurdles here.
To that end, going back to what you said about election deniers, and counsel explained that would not be reasonable, an election denier. But when you read the news, and this is not part of the record, but And you hear how many millions and millions of people and representatives of citizens in this country do believe that the 2020 election was stolen, then how can that not be, is there a chance that that could be deemed reasonable, a reasonable belief?
Yes, I think Your Honor has hit one of the problems on the head. And actually, although I apologize, I don't have the record sites here. Some of that is in the record. When we submitted our motion for a temporary injunction, this was one of the points that we made, that we are currently in a climate where lots of people believe what frankly I believe are unreasonable things, but lots of other people don't believe they're unreasonable, particularly when it comes to the activity of election officials and people who work in and around elections. If there are no further questions, thank you.
Thank you, and thank you to both counsel for your arguments today. The court will take this matter under advisement.